Hi, I am Katharina, the AI avatar representing the publicly appointed and sworn auctioneers of DPV. This video addresses a significant and often misunderstood exit path for value realization in distressed situations. What the market still gets wrong about public auction, and why that matters for speed, execution, and recovery. When market convention misreads legal framework and process quality. Why public auction remains underestimated. In the realization of pledged equity interests in German companies and other pledged rights, including intellectual property, public auction is still too often assessed against the wrong benchmarks. Yet particularly in distressed and special situations, it remains one of the most reliable, efficient, and institutionally defensible mechanisms for final realization under German law, both in purely domestic cases and in cross-border structures. The market's reservations are familiar. Public auction is said to be slow, bureaucratic, operationally cumbersome, reputationally sensitive, and economically inferior, a process fit only for a forced sale scenario. Those objections persist less because they are compelling than because they are repeated. In many cases, they are not the result of close legal or commercial analysis, but of habit, analogy, and misplaced process preference. That is where the error begins. Public auction is not simply another sale format. It is a legally structured realization mechanism with a distinct procedural logic and a distinct institutional value proposition. Its strength lies not merely in exposing an asset to the market, but in producing a final, executable, and defensible outcome. Clear authority, open market price formation, documented process integrity, legal completion, and materially reduced ex post challenge risk. Those features matter in German enforcement scenarios generally, but they become especially important where German collateral sits within London-led financings, private debt structures, intercreditor arrangements, or security agent architectures. In such cases, execution discipline matters as much as price. The relevant question is not which process feels most familiar from a bilateral M&A or enforcement perspective, but which process is actually robust under German law and capable of delivering a defensible recovery outcome. Why the market misreads the mechanism. The market continues to misunderstand public auction for two principal reasons. First, it is often wrongly conflated with judicial enforcement under the German Code of Civil Procedure or the Forced Sale and Administration Act. That immediately imports the wrong associations: delay, heavy formalism, limited flexibility, and procedural drag. But the realization of pledged shares and other pledged rights under the German Civil Code follows a different logic. The relevant framework is not state-led enforcement in the classic ZPO or ZVG sense, which is German law governing judicial foreclosure sales, but the public auction conducted by a publicly appointed and sworn auctioneer is the statutory realization regime of pledge law. Confusing those frameworks leads directly to mistaken assumptions on timing, practicality, confidentiality, and market access. Second, complex collateral realization is often viewed reflexively through the lens of bilateral distressed M&A. That is understandable. In restructurings and special situations, private sale processes offer familiar mechanics: selective outreach, curated buyer groups, negotiation leverage, bespoke process steering, and the appearance of control. Advisors and stakeholders used to transaction-led solutions will naturally gravitate toward those formats, but that preference distorts comparative judgment. A process designed to generate open market competition, objective price formation, and final legal completion is then measured by standards that privilege discretionary control, negotiation flexibility, and buyer curation. Public auction is criticized for not behaving like a bilateral sale process, when in fact its institutional strength lies precisely in the fact that it does not. There is also a more practical explanation. Public auction narrows discretionary influence. It limits the ability to shape the market selectively, steer access asymmetrically, curate preferred outcomes, or later justify price through narrative rather than process. That makes it less attractive to those who prefer transaction formats offering greater subjective control. But from a governance and liability perspective, that reduction in discretion is often a feature, not a defect. Why public auction matters in distressed and special situations. Public auction is particularly relevant where lenders, funds, or security agents are operating against time and seek to avoid slippage into proceedings under the German Act on the Stabilization and Restructuring Framework for Businesses, StREG, or formal insolvency. Delay in realization rarely improves optionality. It usually increases information asymmetries, coordination costs, stakeholder friction, and execution risk. It also increases the probability that the case moves into a more restrictive restructuring or insolvency environment, where authority, timing, and recoveries may become materially harder to control. In that setting, public auction functions as a mechanism of distressed finalization. It creates a market, converts valuation debate into competitive price formation, reduces disputes over purchaser selection, compresses time to cash, and leads to a defined completion event. Its value becomes even clearer where the debtor environment is obstructive. Informal or privately managed sale processes can be delayed, politically challenged, or tactically undermined. A structured, market-open, and properly documented auction process is materially harder to derail. What may appear from the outside to be greater formalization is in practice often superior execution discipline, timing, process structure, and practical execution. Perhaps the most common criticism is that public auction takes too long. In well-run cases, that criticism is frequently unsustainable. A properly prepared auction process follows a clear sequence: verification of enforcement prerequisites, preparation of the data room and transaction materials, auction engagement, public notice, bidder qualification, auction date, knockdown, and completion. This is not a process built around indefinite loops, iterative retrading, or prolonged negotiation phases. It is built around closure. For that reason, in prepared cases, the relevant timetable often runs not in months, but in weeks. A 3 to 4 week execution window is entirely realistic, where the file is properly structured and the process professionally managed. What is often dismissed as bureaucracy is, in reality, process reliability. Defined responsibilities, documentary discipline, transparent milestones, and a stable legal framework are not operational disadvantages in a distressed enforcement setting. They are often the conditions for an outcome that can later be defended before credit committees, co-investors, co-shareholders, insolvency office holders, or courts. From a creditor perspective, the relevant question is not whether a process looks bespoke or transaction-led. The question is whether it produces an executable result within a predictable timetable and at a cost proportionate to the likely recovery. Public auction often compares favorably on exactly those metrics: confidentiality and reputational exposure. Another persistent misconception is that public auction necessarily means full public exposure. That is wrong as a matter of practice. A professionally structured public auction does not require uncontrolled disclosure of debtor-sensitive or transaction-sensitive information. What becomes public is, at its core, the auction date and the asset being auctioned. Commercially sensitive information concerning the debtor, the secured parties, contractual arrangements, or the underlying business is typically made available only in a controlled data room environment, against NDA and subject to bidder screening and compliance review. As a result, public auction is often far less reputationally exposed than critics assume. In many distressed cases, the relevant market already understands that the asset or borrower is under stress. The real issue is therefore not whether the market may become aware of a realization event, but whether the process is conducted in an orderly, non-discriminatory, and later defensible manner. Measured on that basis, public auction is not reputationally reckless. In many cases, it is structurally cleaner than a selectively managed private process whose opacity later becomes part of the challenge narrative. Market opening, price integrity, and best recovery analysis. Public auction is also often criticized as a mechanism that necessarily produces distressed pricing or fire sale economics. That criticism usually rests on a superficial understanding of value. For institutional creditors, the relevant benchmark is not a headline price that can be claimed in theory or asserted in bilateral negotiations. The benchmark is a realizable and defensible recovery outcome. That means looking not only at gross price, but at net recovery after time decay, cost, execution risk, renegotiation risk, failed signing to closing dynamics, and the ability to defend the process later. That is precisely where public auction has substantial merit. It does not merely claim market value, it subjects the asset to open competitive price formation. Reach, bidder access, informational parity, and competitive bidding together create a materially stronger basis for defensible value determination than a process built around selective outreach and negotiated positioning. A bilateral process may, in some cases, appear capable of producing a higher price on paper. But that apparent advantage can erode quickly once advisory fees, longer timelines, buyer leverage, diligence asymmetry, conditionality, retrading, and completion risk are taken into account. A gross headline number is not the same thing as a superior recovery. Public auction is therefore not properly characterized as an inferior or fire sale mechanism. On the contrary, it is a market opening tool that can create competition where no real market would otherwise exist. In complex or politically sensitive situations, that may be the difference between a defensible realization and a contested one. Bilateral private sales and ex post vulnerability. Private sale processes often create the impression of superior control, but perceived steerability and actual institutional control are not the same thing. The more a process depends on selective buyer contact, discretionary information distribution, valuation narrative, buyer preference, or process curation, the more vulnerable it becomes to later challenge. In hindsight, the key questions are not merely whether a price was achieved, but how the process was run, who was given access, whether a genuine market was tested, whether conflicts were managed properly, and whether relevant third-party interests were sufficiently respected. For lenders, funds, and security agents, the most meaningful form of control is therefore not maximum room for discretion, but minimum ex post attack surface. A process demonstrates its value not when it feels flexible during execution, but when it remains robust under scrutiny after completion. That is a core institutional advantage of public auction. It substitutes subjective process management with objective procedural structure, open market access, documented competitive bidding, and a final completion event. What may seem like less flexibility often turns out to be more protection. Insolvency law context and the limits of relying on later private sale. This distinction becomes particularly important in light of German insolvency law. A persistent assumption in the market is that an insolvency administrator can, as a practical matter, realize pledged shares or other pledged rights in substantially the same way as movable assets or assigned receivables. In share pledge structures, that assumption is dangerously imprecise. At the latest, since the German Federal Court of Justice's decision of 27 October 2022, XZAR 145/21, it has been clear that the insolvency administrator's statutory realization powers under Section 166 INSO do not extend to pledged shares, assigned or pledged IP rights, or other comparable rights. Section 166 INSO covers movable assets in the administrator's possession and claims assigned by way of security, but not other rights. That distinction is critical in enforcement structures involving shares and intellectual property rights. The practical implication is obvious. Share pledge enforcement should not be structured on the assumption that, if necessary, insolvency will later provide an easy substitute route through a private realization logic. Where realization authority does not automatically migrate into insolvency-led private sale, the need for a robust pre-insolvency execution mechanism becomes more acute, not less. In that context, public auction is not an eccentric special case. It is a legally coherent and practically reliable realization route. The same caution applies to Section 1245 BGB. While that provision allows, within limits, deviation toward private sale, it does not make private sale the institutionally superior solution. Quite the opposite. The less open, documented, and objectively verifiable the process, the greater the challenge risk becomes. Undervalue allegations, shareholder claims, insolvency-related challenge theories, and accusations of selective buyer steering attach far more naturally to a privately managed process than to a properly documented public auction. Finality, legal completion, and liability profile. The deepest institutional strength of public auction lies in its finality. The knockdown is not a preliminary commercial understanding. It is the legally operative completion event. Signing and closing collapse into one. That matters enormously in distressed situations where delay, conditionality, buyer back-end leverage, and post-agreement renegotiation can materially impair recoveries. It also matters from a governance standpoint. Public auction does not merely produce a transaction narrative, it produces a documented market event. The process record, the competitive dynamics, and the completion act together provide a materially stronger evidentiary basis for later defense than a private process built on negotiation history and valuation justification. That is why the liability profile is often materially better. The more a realization mechanism depends on clear authority, open market access, documented process integrity, and definitive completion, the lower the typical challenge and liability exposure for those charged with execution. For security agents, lenders, and fiduciary decision-makers, that is not a secondary benefit. It is often central, particular relevance in cross-border financings and intercreditor structures. Public auction is especially important where international financing structures connect into German collateral packages. That includes London-based lenders, private debt funds, mezzanine investors, security agents, and intercreditor structures dealing with pledged equity interests in German entities. In these cases, parties often default to familiar Anglo-American enforcement assumptions or bilateral sale conventions. But what matters is not which route appears most familiar from a documentation or deal execution perspective. What matters is which route is actually valid, executable, and defensible under German law. That is where public auction has particular force. It creates a clear bridge from collateral position to final realization within a process that is legally structured, procedurally stable, and documentary strong. That is especially valuable in intercreditor settings. In multi-stakeholder structures, ambiguity over authority, realization strategy, value determination, and completion can become a material source of friction and risk. A realization route that narrows discretion, clarifies process, and converts execution into a structured legal mechanism can materially reduce both execution risk and internal stakeholder challenge risk. Where several creditor constituencies, a security agent, divergent recovery expectations, and potentially obstructive debtor behavior converge, a process that produces closure is often worth more than a process that merely preserves negotiating room. Conclusion: the principal criticisms commonly directed at public auction do not withstand close examination. In well-structured cases, it is not slow, but capable of execution to a fixed timetable within weeks. It is not unduly bureaucratic, but procedurally disciplined, tested, and defensively documented. It is not operationally unworkable, but often highly effective in complex distress scenarios. It is not inherently reputationally damaging because commercially sensitive information can be controlled through a screened data room process. Nor is it an economically inferior route. Properly run, it is a mechanism that creates competition, broadens market reach, supports defensible price formation, and produces legally meaningful completion. Its institutional value lies in the combination of legal coherence, process integrity, finality, execution certainty, reduced challenge exposure, and defensible value realization. That is exactly what makes public auction a serious tool for lenders, funds, security agents, and other stakeholders operating in German collateral enforcement, not only in domestic cases, but also in cross-border and intercreditor structures. Against that background, the current European legislative direction is notable. The proposal of the European Parliament and of the Council on the harmonization of certain aspects of insolvency law, adopted on 30 March 2026, reinforces creditor interests through control, market testing, and value preservation. That is precisely why public auction remains relevant, not as an outdated alternative, but as an objective mechanism of price discovery and transactional legitimacy, particularly where fair market value is contested or the integrity of a pre-arranged sale process is open to question. Article 24-3, for example, contemplates public auction as a means of ensuring achievement of fair market value. Thank you for your attention. Should you have any questions regarding a specific case, please do not hesitate to contact us.